the defendant would be Mr. Perez Hernandez. Mr. Marufo, has that person tried to log in?
No, sir. I don't see nobody in the waiting area by that name, sir.
All right. Well, this is set for a status. And it looks like also there is a reference to a motion to retain, which I assume is a motion to retain counsel.
Your Honor, I believe, I'm sorry, go on.
Go ahead, I didn't hear you.
Your connection's not great, Mr. Kettler. So I don't know, don't move and
Understood.
meter your speaking, please. And I don't know which case. Could you please call it?
Bottom of page 2, Judge, in cause number 2022 DCV 2975 TD Bank N.A. versus Renault E. Perez Fernandez. Announcement of counsel, please.
Good morning, John Kettler on behalf of TD Bank.
And there is nobody appearing on behalf of Mr. Perez Fernandez, and he is not logged in. Is that correct?
Correct, Judge.
All right. Well, tell me what you think the status of this case is, sir. Mr. Kettler.
Well, Your Honor, I've indicated that this case has had service perfected for some time. Plaintiff is looking to dispose of the case within a reasonable amount of time. They do need some additional evidentiary documents to prepare their plaintiff's motion for default judgment to present to the court. If we could respectfully request, we could respectfully request to retain the case and set it either for an additional status, or if it would please the court, a default setting, then I believe that that would give the plaintiff enough time to get their documents in and present that to the court within the allotted time per the rules.
All right, well, let's reset this for 30 days. Hopefully you can get everything done within that time.
Sounds good, Your Honor.
All right. So, Ms. Hernandez, if you'll send out a notice, this will be reset for 30 days down the road.
Yes, sir.
Any others ready to go?
Yes, sir. On page 3, Judge, the second and third one, Judge, in cause number 2021 DCV 3182 Joaquin Segovia versus Philip Edgar Cook. Announcement of counsel, please.
Michael Alvarez for the plaintiff.
Yes, up here for defendant Cook, Judge.
Okay, this is two. Well, I'm a little confused. We got this listed twice as two cases, but it seems to have the exact same number on both cases. Is this one case or two cases?
It's one case, Judge. There's two motions. I don't know if that might have been why you have it listed twice.
Okay, yeah, I've got a motion to compel and also a motion hearing. So tell me what, let's take the motion to compel first. Whose motion is that?
It would be defendant Cook's motion to compel, Judge.
All right, tell me what you want to get compelled.
All right, Judge. We filed a motion to compel after sending a discovery dispute conference to plaintiff's counsel. In the deposition, we took plaintiff's deposition, and during his deposition, he acknowledged some significant additional treatments, a medical disability diagnosis. He testified under oath that he'd been given a disability diagnosis and had been receiving benefits for many years, Judge. That was not disclosed in plaintiff's answers to interrogatories. He also identified a Dr. Picasso at Southwest Boulevard, who is affiliated with the University Medical Center. We sent plaintiffs to counsel a request for those records after the deposition, and we have yet to receive those. He also said that he treated at Houston Scoliosis and Spine Institute and gave dates of service in December, January, February, and March 2022 and April 2022. We've gotten bills for them, but we've never received the corresponding medical records. He also testified that he received an MRI off of Osborne Street and that MRI formed the basis of his treatment with Houston Scoliosis and Spine. We've never received that record. Plaintiff objected to interrogatory number 8, in which we asked him if he had ever had any previous treatment to his spine, muscles, ligaments, or that were orthopedic in nature. Despite their objections, plaintiff answered in his interrogatory responses none, During his deposition, he testified that he actually had a 20-year history of scoliosis and arthritis. And we're seeking that he amends his answer to include additional information about that. Interrogatory number 5, he objected to as a collateral source rule. When we asked him whether he was a disability beneficiary and had made any disability claims, which he did confirm in his deposition that he has been disabled, but they haven't produced any information regarding the diagnosis and course of treatment. With regards to interrogatory number 11, plaintiff objected that it constitutes a that since he's not a physician, there are other sources that are better to provide information regarding every doctor and healthcare provider who has treated him for injuries he's claiming in this accident. Judge, we believe that objection is unfounded and would ask him to remove the objection to fully answer that. And then finally, interrogatory number 12, we requested information from plaintiff regarding regarding medical providers who have treated him. Plaintiff objected, stating that that was a unfounded fishing expedition, Judge. And again, based off his sworn deposition testimony that he suffered from chronic arthritis and psoriasis and scoliosis, which he has been treating for, we're just requesting those records, on Your Honor. Once we have those, I think we'll be in a position to evaluate his claims. But we can't evaluate his claims without knowing the basis for his disability and all of these other treatments that are related to this accident we've not been provided, Judge.
Okay, I was just handed a copy of a response to these motions that apparently was filed yesterday afternoon. Have you seen it is a response and also a motion for leave to extend the deadlines. Have you seen that, Mr. Jessup?
Yes, Judge, I've seen that. That is with regards to my other motion, a motion to strike the late filed 1801 affidavit. Judge, I believe that's the response to that one. I've not seen a response to the motion.
Would you repeat that? That was a motion to strike.
Yeah, go ahead.
Sure, I'm sorry. I did receive the response to our defendant's motion to strike, Judge, and so I did receive plaintiff's response to that. I have not received a response to our motion to compel.
Okay, well, Mr. Alvarez, tell me about your position with regard to the motion to compel.
Yes, Your Honor. With regard to the motion to compel, I wish I had a little more time to streamline the issues for today. We just got a hold of our client yesterday and had a talk with him by phone. I don't blame counsel for bringing the motion before the court, though. He's been very patient with us. I think for the most part, we should be able to resolve all of the deficiencies. I have not reviewed the information.
I'm sorry, sir. There's such an echo. Is it your echo?
There's a lot of static.
It's a repeat. Is somebody playing the YouTube feed at the same time that we are making? Mr. Jessup. I'm gonna mute you, okay, Mr. Jessup. I'm just gonna mute you. Go.
Okay, as I was saying, Your Honor, I believe that we should be able to reach an agreement as to most of these deficiencies. Regarding the disability diagnosis, we did find out about that for the first time at the deposition, and we just hadn't been able to get more information from our client, but we spoke with him yesterday. I have not had a chance to review the notes from that conversation. Our staff spoke to him, and so I believe we should be able to supplement the request regarding the disability diagnosis. With regards to the records requested from Dr. Picasso, we can't produce those because we don't have those. We have made those requests. We've been getting the runaround from, these were services that were provided at the hospital. And so the hospital was sending us to the physician's clinic was sending us to the hospital. And then at the end of it, it turns out somebody had the wrong social security number, not us, the system that the medical providers had something wrong with the social security numbers. So we don't have those documents. We're willing to provide a release for them, but we're also working to get those directly. And as soon as we have those, we will produce those. We do have documents from Houston Spine and Scoliosis Institute. If we produced those on March 2nd, if anything is still missing from those records, we'll be happy to provide those because I believe we have them. The MRI referred to is also, I think, a record from Southwest X-Ray, which we produced on January 20th, 2023. And again, if those somehow didn't make it over to counsel's office, we'll be happy to produce those. with regards to, I believe I heard counsel mention interrogatory number 8. Our objection has to do with the overbroadness of the request. It's requesting records for the past 10 years. Now, again, this may be resolved by whatever information we provide regarding the diagnosis, the disability diagnosis. We believe that's really what counsel is looking for. But until I can review the information that we just got from our client yesterday evening, I have to stand on our objection to interrogatory 8. Regarding interrogatory 5, that's the disability diagnosis. We will provide those without that information without objection. With regards to interrogatory number 11, we will also answer interrogatory 11 or produce documents from which the answers can be obtained. With regards to interrogatory number 12, again, I have to stand on the objection because they're being overbroad in scope, because they're looking for a period. They're looking for every hospital, physician, healthcare provider for the past 10 years. We think that's overbroad. So again, we may be able to provide enough information for counsel to do what they need to do. But until I can review the information we obtained yesterday evening, have to stand on that objection.
Mr. Jessup, your response?
Yes, Judge, with regards to those supplements, certainly if he supplemented those, I would appreciate those. I was looking at my file while he was talking. I've not seen those come in from his office. With regards to 10 years being overbroad, Your Honor, first of all, they did object, and then they said subject to and without waiving the foregoing objection. The answer was none. Well, that wasn't true, Judge. In his deposition testimony, he did swear under oath that he has been diagnosed disabled. They've been treating him for back scoliosis, possibly psoriasis, Judge. But we want to know the basis for the disability and for treatments. We don't think 10 years is overbroad, but of course, Judge, with regards to what's relevant once we get those records, I think that's an evidentiary determination, Judge. But I think we're entitled to it. We're just trying to determine the nature of his disability, the nature of his back and neck problems. Of course, in this case, he's claiming back and neck injuries as a result of our accident. So, Judge, I think they're relevant. I don't think it's an overbroad, unrealistic period of time. And so that's why we requested those, Your Honor. The other objection, the number 12, or number 12, again, he says that it's a fishing expedition. Which we're seeking is any hospital, physician, or healthcare provider who treated him for injury sustained in this accident, Judge. I don't know how that's overbroad. That's not seeking that. And then we ask for any other accident or incident during the last 10 years, Judge. And I think it would be relevant if he's involved in any other accidents or incidents causing injury in the last 10 years, Judge. Again, I don't think it's overbroad or unreasonable. But again, he has objected, but he also said in his answers before his deposition, he said there was no other medical providers. Well, he disclosed that there are additional medical providers in his deposition, Judge. So that's what we're trying to get at the heart at, is what was his medical condition before this accident in order to determine what issues that he's now suffering from, what is related, Judge.
Okay, well, what I'm going to do is, I'm hearing an echo. Is there an echo?
Yes, sir. I went ahead and muted the box.
Oh, okay, thank you. We're going to reset this hearing for 30 days. Mr. Alvarez, get everything that you say you've already gotten or are about to get to Mr. Jessup. I'm going to defer any ruling on any costs or sanctions until Mr. Jessup gets everything. He's free to re-raise that if he thinks he should re-raise those claims. But get everything you can to it. I think the request for records from any treating physician from this accident is not overly broad. So I'll deny that objection. For now, I think 10 years, it's maybe on the long side, but for this type of an injury, I'll let him go ahead and seek those records for the last 10 years. So with that guidance from the court. Try and get everything you can to him to respond. And we'll, or not we, Judge Perez will rehear this in 30 days. Okay.
Thank you, Judge.
Thank you, Judge. Did you want to roll the other motion over to that as well, Judge? It's another evidentiary one.
Yes. Yes, they seem to be
Okay.
somewhat similar, so we'll do them both at the same, 30 days from now.
That makes sense. Thank you, Judge.
All right. Thank you.
Thank you,
That's
Judge.
all I have. Thanks.
May I be excused?
Okay. Mr. Marufo, we got any others ready to go?
Yes, Judge, bottom of page 2, Judge. In cause number 2022 DCV 2401 UT Company LLC versus Azen R. Salcedo. Announcement of council, please.
Good morning, Hector Beltran on behalf of the plaintiff UT Company.
Is anybody appearing on behalf of the defendant?
Not in the waiting area, Judge, no.
Is there an attorney for the defendant, Mr. Beltran?
Your Honor, I don't believe there is. We secured service after quite some effort, and there is an insurance company involved, but they have not retained counsel or anybody to help the defendant. We're in a position to take a default judgment, but we have some unliquidated damage claims that need to be presented to the court. We're working with a third party who's owed some money. This is an accident case, but it's a damage only. It's a property damage case. There was a trailer attached to one of my client's vehicles that was all but destroyed. That trailer was taken to a third party who continues to store the trailer. And so damages continue to accrue. The insurance company tried to give us a small check and claimed that that was settling the case. If it's not accepted, we've sued the party who caused the accident. Whether they've given it to their insurance company or not, I don't know. We certainly advised them to do so. And so at this point, I guess if we can get a default setting, I would say in about 30 days, we should be able to present the evidence by that time. And hopefully we'll get an answer filed that, the defendants will step up and their insurance company will get them counsel. This is not an exotic case. It should be settled. It should be resolved. But to date, Allstate has not been working with us.
Okay, well, let's set it for a default hearing 30 days from now. So that'll be into June. Mr. Hernandez will send out a notice.
Sounds great.
Okay. All right, thank you.
Thank you, Judge. May I be excused?
Yes, you are excused.
Thank you.
Marufo, we got any others ready to go?
Yes, Judge, staying on page 2, in cause number 2022 DCV 2829 GECU versus Victor Rico Rodriguez. Announcement of council, please.
Good morning. This is Anna Adamo, attorney for plaintiff GECU.
And I don't hear anybody. Is there a lawyer for the defendant, Victor Rico Rodriguez?
Your Honor, I do not show that there's an attorney here, as I don't show that we've obtained service at this point on this case. We were prepared to allow a dismissal, knowing that we don't have an address to attempt at this time to further service attempts.
Okay, well, if you want to dismiss it, I don't think anybody's going to object to you dismissing it.
We never want to dismiss, but unfortunately, I don't have another reason for us to move forward. So knowing that's kind of where we are right now, we have notified our client and they too did not provide us with an address that we can attempt at this time. So we're prepared for it to dismiss. And then if something happens later down the road and we still have time, then we'll see what we can do then.
Okay, so when do you think you can get a motion to dismiss filed?
Is that something the court would like us to file a motion to dismiss?
I would think so, if you're prepared to dismiss it. I mean, it would be without prejudice, right?
I mean, yes, if the court will just keep the case open, we can try to keep attempting service at new addresses.
It's a 2022 case.
That's right, Your Honor.
We'll just keep it open. Why don't we set this for another status conference 60 days down the road?
That would be wonderful, Your Honor.
Good.
We'll see if we can keep digging and hopefully we'll find something.
All right, good luck to you. You'll get a
Thank you, Your Honor.
setting for 60 days.
Okay, I'll jot that down. Maybe excuse, please.